All right. Hi, welcome back. Attorney Steve Vondran here. Welcome to another exciting episode of Litigation Whiteboard. We are talking in this video about copyright attorney fees. I know. You're like, whoa, geez, can you get something a little more exciting? Well, this is exciting. So without further ado, let's head to the Attorney Steve Litigation Whiteboard. All right, so let's back it up here. So we are talking about our copyright attorney fees. I have the finger out today. Don't get mad. Give them the finger. Attorney Steve finger. Okay, so we are talking about copyright attorney fees. Now, in general, this is general legal advice. This is, strike that. This is general information only, not legal advice. So the rules may differ in your jurisdiction and your circuit courts, whatever. This is general information, okay? But people will say, well, who pays attorney fees in a litigation case? Is it the plaintiff? Is it the defendant? The American rule is that you pay your own way in litigation. If you're going to go into court and you're going to sue somebody, you pay your own way. If you're going to be sued and you're a defendant, you're being sued, pay your own way. Even if you win, you pay your own way. That's called the American rule. But there are exceptions to that, especially where you have a contract that provides for attorney fees or a statute. So what's beautiful about copyright law is that we have copyright attorney fee statute. We have it right here. Section 505 of the Copyright Act talks about specifically being able to recover not only your full costs, quote here, full costs plus and reasonable attorney fees to the prevailing party. So here's our prevailing party, just won a big willful infringement copyright case. Maybe it's a photo infringement, maybe it's software infringement, maybe it's any kind of art infringement, all kinds of infringements, okay? So prevailing party says, Judge, I want my attorney fees. And the judge says, well, let's look at Section 505. All right, it looks like you get your full costs. Now I put here, look at Section 28 U.S.C. 1821 and 1920. Those will talk about the costs that are recoverable, like copying and printing and transcripts, court-appointed expert witness fees, things like that. So that's going to be your full costs and a reasonable attorney fee. Now, this is where copyright litigation can get expensive. The losing party can be hit with a big, giant attorney fee award. Now, these have to be reasonable. The judge is probably going to require a declaration and basically ask you to quantify your time spent, how many years you've been practicing, is your fee reasonable in the jurisdiction, that kind of thing. But this is what we call fee shifting, because this is different from the general rule, the American rule, where you pay your own way. So this is fee shifting. This is going to come down on somebody's head here. So if you're the prevailing party in a litigation, and there's some subject of debate on actually what is a prevailing party, you're entitled to seek these damages. Now, you need to know that in copyright law, this is discretionary, okay? This is what we call up to the judge. The Fogarty factors, the big United States Supreme Court case on this is the Fogarty case. Fogarty case talks about these factors, okay? And then this one was added on from another case. But these are the 5 factors the courts are going to look at when they decide, should I hit somebody with attorney fees? Should I have the discretion, should I say each party bears their own fees? Or should I have the defendant pay? Or should I have the plaintiff pay? So here's the factors. Let's take a look at them. Number 1, degree of success. To what extent did this prevailing party succeed? Did they have a complete and total victory and just squash the other side, and the other side had no reasonable defense and they're entitled to their attorney fees? The degree of success. Now, many courts will say if you establish the liability of a defendant, for example, you show that they were an infringement, it was willful. Even if it was non-willful, it's still infringement under copyright law. So if you show that you've established a liability that the defendant was liable, a lot of courts say you have a good degree of success there. Now, but I want to point out something. Mark your calendars here. Tomorrow, I'm going to be doing a video on the Rule 68, FRE, Federal Rules of Evidence, Rule 68, on the offer of judgment. So that's important because in this case, in a litigation case, one party may have made this offer of judgment. And what that is basically is if you don't do better, at trial than the offer that they were giving you, then you may not be able to cover your attorney fees. So this is a separate topic. Bookmark that. That's coming out tomorrow. So, and real quick, you see I have 6 factors here. The court looks at these in what we call the totality of the circumstances. So when a court's rendering a decision on the attorney fee award, whether to grant it, whether not to grant it, whether to limit it, that's up to the judge. It's discretionary, but he or she should factor in or analyze all these factors. So as a defendant or a plaintiff, you want to be prepared to discuss each of these in your motion for attorney fees, okay? But let's move on. Number 2 is frivolousness. Was this a frivolous case? Did the defendant raise a totally frivolous defense? Like, let's say you downloaded and copied a movie and broadcast it in a theater, and you said, well, it's scenes of fair. It's the scenes of fair defense or the first sale doctrine, things that clearly don't apply. That's frivolous. That's a frivolous defense. That's a factor that the court can weigh. Number 3, motivation. This is where the court looks at the good faith and the bad faith of the parties. Are they bringing a suit just to harass somebody? Is this something that the defendant should have caved in a little bit earlier and made a payment instead of, settled the case instead of dragging it on forever? Those kinds of things. And here I have creator fair use versus a pirate. There's going to be a difference between the person that's accused of, let's say, software piracy, downloading software, installing it on all their things, and that's copyright infringement, and they fought the case. And the court says, this is a pirate. This is just a pirate, okay? Versus someone who maybe it's an artist who tried to transform a song, or somebody that tried to sample a song in the Ninth Circuit. There is a de minimis use in the Ninth Circuit. So maybe it's a creator doing something like that. Well, that may not be seen as such bad faith compared to that. So it's really the context. Now, number 4, this is a very important one. Some people say this is the most important one, but it's the objective reasonableness of the parties in their factual arguments, their legal arguments. It's the objective. Does everybody know what objective is? That means from what an outside people would view, not internally. That's subjective. That's what I think. But objective is how other people would see this. Were the arguments, claims, defenses, were they objectively reasonable or were they unreasonable? Okay. And number 5, here we have the need for compensation and deterrence. Anybody that knows copyright law knows that copyright law and all intellectual property, and for that matter, patents and trademarks, they're designed to incentivize the creators, to protect them for a limited time, okay? To provide for the public good is another goal for copyright law, okay? So this question's asking, do we need to compensate and deter if it's within the goals of the copyright, considering all the equities of the case? Okay, so this is something that's going to get weighed. Finally, last one, number 6, chilling effect of attorney fees, burden on a poor plaintiff, or what they call impecunious. Alexa, what is impecunious?
The adjective impecunious is usually defined as having little or no money, penniless, poor.
See, did I tell you? Thank you, Alexa. So that's it. That's a general legal overview. Just remember, in a copyright infringement case, if you end up on the losing end, this is a very important thing that you have to know. There are factors. It is discretionary. Who's the prevailing party? To what extent did they prevail? Good faith, bad faith, all this good stuff, objective reasonableness. This is the analysis that you go through. This is the analysis that the courts are going to go through in deciding who should get an attorney fee and how large or small it should be. So I hope you found this information helpful. Not something you hear you don't learn this in junior high or high school, college, anywhere. Only here on Attorney Steve channel, okay? So I hope you like this. Give me a thumbs up if you do. Give some comments down below if you're not. Otherwise, make sure to subscribe so you get this great information coming to you right there. Just hit that little subscribe and you're good, okay? So we'll see you next time with